All right, so welcome back to Trials and Tribulations. Today, we're going to continue to talk about the effect of the tort reform bill here in Florida. As well as some of the backlash that's occurred from some communication from plaintiff lawyers. You know, one of the things that's been sort of, I think, unfair is that in recent days, plaintiff lawyers have finally started to speak up and use their voice in a way that really explains the negativity that surrounds this tort reform bill. As we talked about in our last episode, the folks that are proponents of this manufactured term tort reform have always been loud voices talking about how terrible the trial lawyers are.
Effective messaging.
Right. Saying how terrible we were as trial lawyers.
Messaging that resonates even when people who are buying into that message are the ones who are ultimately going to be suffering. I think that was a big theme that we explored last time we spoke about this.
And that's acceptable in society to say that the trial lawyers are terrible. We're big bad people who are greedy. We want to, raise insurance rates. We bring frivolous lawsuits. We do all these terrible things, and all of the plaintiff lawyers are just bad people. That's the message that's being sent to the world, and the world has accepted this. And everyone who portrays that message in the media sees no problem with saying that every single person who's got a law degree that practices as a plaintiff lawyer is some kind of a greedy bad guy.
Yeah, it's not a very controversial thing to say.
Not anymore. But what I find to be, I don't know if it's ironic, but it's unfair and unreasonable, is that when the plaintiff's bar fires back and does something to counter that argument, people act like this is terrible. It's so unethical. It's so unprofessional. How could plaintiff lawyers possibly say all these negative things about the way they're going to treat defense lawyers and insurance companies? And I think that we need to draw the line and stop this nonsense, because it's not right for folks to be able to go out there and paint our profession for the last 25 years as being so awful when all we do is try to help people who have been harmed that don't have a voice. But then when we fire back, we're looked at as being unprofessional. It's improper. And what I'm really referring to is Morgan & Morgan, who's one of the largest law firms, maybe the largest plaintiff law firm in America, decided that they were going to take a stand, take a position because of tort reform.
A firm position.
A very firm position. And the results have been, I think, on the plaintiff side, we all see it as being pretty positive, but in the media, it's looked at as being unprofessional, which I think is totally unfair.
But let's stop for a second, because they took a position. Not just a position, but a public position. We know full well that there have been a lot of positions taken leading up to this legislation, leading up to the bill being signed into law. There's been a lot of positions being taken, but not publicly. And before we even get into this, that's a problem in and of itself.
What, that it's being done in like back rooms and being negotiated?
This position, I think, is shared by a lot of people, by a lot of plaintiffs' lawyers, but it's never been shared publicly. While the other message, the counter, has been shared publicly very effectively. So this is, by many accounts, the first time that a public position has been taken. It's been published, and it's made national headlines now.
And hopefully, through the editing process that we're doing here, our folks can figure out how to put it up on the screen. But I'm going to read it. I'm going to read it real quick. This is the letter that was written. I think it's an internal memo to all the lawyers at Morgan & Morgan. But it was leaked. It got out in public, probably not by accident.
Right.
And it says the following: Good morning, PI lawyers across the country. As we enter this new era, I want to make it unequivocally clear that we will not give any inch to carriers ever again, not 1 inch. Specifically, as a matter of policy, we will not be granting any extensions or any sort moving forward for any reason. They can figure it out or file a motion. Under no circumstances will we be agreeing to any continuances, discovery extensions, or requests to extend deadlines to answer complaints. Red line rules. It will be a serious internal offense if we find any courtesies being extended to the insurance industry, including cases filed prior to March. No discovery extensions, no matter the circumstances. We want to help the human being defense attorney because we know them and maybe we like them, but we will not because they work for an enemy who is heartless and ruthless. The enemy who just tried to kill us in Florida. They work for the enemy who would like nothing more but for you to be unemployed. We work for the people exclusively. They try to take the most vulnerable people and consequently from your families. No extensions for responses to complaints. If there are extenuating circumstances that would benefit our client only, please reach out to us for prior approval. As a blanket rule, we will not be giving one single inch. Let's effing go. It's a great message. I mean, I see it as this. Obviously, Morgan & Morgan has a huge platform because they do represent the largest plaintiff firm in the United States. So I think they have the voice and the platform to be able to say this on behalf of a lot of the smaller firms that might not feel as confident to go out in public and say these words. But if you look at what they're saying, I don't see it as being that controversial. Defense lawyers have gone ahead and removed rights from people at a very extensive rate here in Florida. And as a result, no lawyers are going to lose their jobs potentially. There's going to be a limit on what victims are going to be able to get compensated, both from property claims and personal injury claims. All these folks at Morgan & Morgan are doing is reacting to that by saying, if you're going to do this to us, then we don't feel the need to be courteous to you. Well, and I don't see a problem with that.
First of all, I think it's meant to be provocative, and it was effective if that was the intention, number one. Number two, I think it's important to draw the distinction, as that message does, between the defense lawyers and the defense bar and their clients. I think that's the one area where I think some people have gotten their feathers ruffled a bit and say, all right, you have to draw a distinction between our colleagues who are attorneys, they happen to be on the other side of the V, and their clients, the insurance companies who were really instrumental in getting this legislation pushed through. I think that's one thing. I think the other thing to talk about are these perceived issues of professionalism and ethics. They're all important. But after reading this several times, after speaking with some people who we know, what strikes me most is that Morgan & Morgan and plaintiffs' lawyers in generally and sincerely believe in their mission to protect people against bigger forces. Mm-hmm. We genuinely believe in that mission, believe in that role, believe in that societal responsibility.
Right.
And I think that it's unfair when someone expresses that emotion, and I think it's a passionate message to castigate them for it, or to somehow say that it's unacceptable to express that opinion publicly. I view this, when you scrape away all of the things that are meant to be provocative, I really see a passionate plea here. And I think that it's important and it needs to be viewed that way.
Yeah, and I agree with you. But the thing is, when you read what they wrote and the way that it's being portrayed by the defense, by the insurance industry as being so unprofessional, it's completely forgetting the way in which those same folks who are crying foul speak about the legal profession from the plaintiff's side. They don't mince words. They use words like greedy. They use words like blood-sucking, abusive, frivolous. They claim incorrectly and inaccurately that plaintiff lawyers are responsible for higher insurance premiums. So they blame it all on the plaintiff lawyers. So when the plaintiff lawyers are constantly getting punched in the face over and over again, and as a result, their clients are losing their rights, how can anybody be unhappy or upset that those folks are getting up and standing up for themselves? I think that you can only take somebody so far and only hurt their career, only insult their profession, only hurt their clients so much before they have to stand up and say, you know what, enough is enough. We're not going to do anything unethical. However, if we're given the choice to either play nice in the sandbox or play exactly the way that you all have been playing for so many years, I think there's nothing wrong with saying an eye for an eye.
Well, if anything, it puts this into a different lens. The important role that plaintiffs' lawyers play, not just in Florida, but in the entire country, and the check and balance that does produce between the average person and more powerful interests. And this is just another episode in that history, and I think it highlights the importance of the role that plaintiffs' lawyers play, and attorneys in general, but particularly plaintiffs' lawyers who agree to represent clients on a contingency fee basis, this highlights the important role that we play in society. And it also highlights, unfortunately, what can happen when that balance is disrupted.
Well, you have to also consider here, like what people may not realize is when the deadline for signing this bill came about, there was a rush to file lawsuits because the bill was not retroactive. So in other words, the day it was signed was the day it became effective. So any lawsuit that was filed prior to the signing of that bill would not be subjected to the bill itself. So these lawyers, the big firms, the small firms, they went out of their way for their clients to file tens of thousands of lawsuits to beat that deadline.
It was statewide, not just Morgan and Morgan.
Right, but we use Morgan and Morgan as like sort of the example, but then we can talk about how this impacted smaller firms. So Morgan and Morgan allegedly filed 25,000 lawsuits.
Yeah, that's what they said.
Every lawsuit in the state of Florida costs about $400 to file. So do the math. That's $10 million. So they went ahead and spent $10 million.
Just to file them.
But why? To protect their clients. You know, they could have waited, but they didn't. They did that to protect their clients. They have a huge firm that I guess presumably has the available cash to be able to file that volume of lawsuits. But think about the smaller practice. The same smaller firm that's trying to do the same thing to protect their firm or to protect their clients. And let's just say they have 100 cases that they otherwise would have waited the right amount of time to file had it not be for that bill. 100 times 400 is what, 40,000? Is that right? Yeah, so you're talking about spending $40,000 to file lawsuits. Those firms might not have that type of cash just laying around, but in order to do right by their clients, they had to do that. Sure. They had to file those immediately. That's the impact of this type of law that's sort of shotgun.
It shows you the seriousness of the impact.
Right, but it also shows you that for all the labels that are being put on plaintiff lawyers, when it comes down to it, they go out of their way to do what's right for their client, even at their own expense, at the harm to their own business. And I think that's why the reaction has been so visceral.
Yeah, but that's why I've read that message several times, that memo several times. And for me, what resonates the most is the sincere passion that these attorneys feel for their clients and for their mission and their responsibilities and their duties. I think that's something that always gets missed when we talk about, whatever side you take, whatever position you take. At the end of the day, attorneys have a very sacred responsibility to their clients. When we all, we take the bar exam, we get sworn in, we take an oath, and we believe in it. And we take that very, very seriously. And sometimes that causes us to be passionate about what we do. Most of the time it does.
But listen to this. So, I read you what was written by Morgan & Morgan that's caused all this controversy. The president of the Personal Insurance Federation of Florida, a person by the name of Michael Carlson, when he was asked about this wave of lawsuits that was being filed, which I accurately just described as a necessity to protect clients. Like this is something they had to do to protect clients. His response was this. This is what he said. Quote, "This is the exact reason the state of Florida needs this tort reform bill. These opportunistic lawyers are acting in bad faith by sprinting to file 25,000 cases ahead of the law's passage." Actually, that was Neil Aldridge, president and CEO of the National Association of Mutual Insurance Companies. He said, this last ditch stunt is yet another example of how legal system abuse has added to the challenges of providing insurance coverage in the state and increased costs for consumers. I don't even understand what that means, other than this guy is arguing that lawyers doing their job, protecting their clients, is a stunt, and it's the reason why we need tort reform. So these guys are arguing that Morgan & Morgan saying that they don't want to provide certain courtesies to their adversaries is somehow terrible, unethical, and unprofessional. But these folks can go out and say that when these lawyers quietly go about their business to protect their clients, that is a stunt and they are opportunistic for doing so.
A couple things. First, that message is the same recycled message that's been used for, 20 years. It's the same thing. It hasn't been changed at all. It's effective. It resonates, and that's just a recycled thing. Same words, same thing. You can probably find 100, thousands of quotes using the same exact messaging.
It's a political stump speech, ultimately, right?
Right. because they found like this works. They probably had focus groups, this and that and that. Going back to Karl Rove, that message works, number one. Number two, a stunt. All right, let's break it down for a second. I'd argue that if a lawyer who has several cases that are about to be filed, if that lawyer did not file those cases before the deadline, I think it'd be almost negligent.
Legal malpractice.
Potentially.
That's exactly what John Morgan said in an interview, that he said it would be legal malpractice to not file them. Yes.
Yeah, it's an extreme way of looking at it, but I think the argument can be made that if you have these cases, you need to be diligent, you need to get everything together. The cases that can be filed, every single one, you have an obligation to get that done.
The filing of those 25, 50, 75,000 lawsuits, that isn't the fault of the plaintiff's bar. That's required to protect victims' rights. So the new flood that's going into the court system of all these cases is the direct result of the decision to pass this law. When things happen, when laws are passed, there are consequences, maybe unforeseen. And I guess the folks who passed this law didn't realize that when they did so, the reaction was going to be, oh my God, we have to do everything we can to protect our clients. We better file tens of millions of dollars worth of filing fees to get these cases in suit. Otherwise, our clients are going to lose their rights. So to attack that as somehow being opportunistic, and then to argue that taking the alternate position that we shouldn't provide certain extensions of time is unethical, I think that is where the messaging from that side has been effective, but it's also extremely misleading and very unfair.
I agree. I'll say one last thing. I think perhaps one reason why this internal memo has been so provocative and caused a lot of ill will is that it singles out insurance companies. Sure, I think that's maybe a myopic way of looking at it, but it's not just insurance companies. I'll go back. It's the dynamic between the average person and larger interests. It's not just insurance companies. It's you can take any swath of business and the organizations that represent businesses. This sort of legislation resonates with them as well. And sometimes it's ironic because they can find themselves on the other side of this sort of thing.
No,
so
it's
that's
true.
where you get into this, how effective the messaging has been, but sometimes the people who are supporting that, because they say, oh, well, it makes sense, they can find themselves on the opposite side of that when they're the ones who need to make a claim, when they have some issues and they have coverage disputes.
Well,
so it's very complicated.
So my biggest concern now of this whole bill, I think the biggest problem, there's a lot of problems, is the property issue. I'm worried that the next time there's a hurricane, the insurance companies are going to use this as a way to decline coverage or deny coverage. They're going to argue this is a flood. The flood's going to argue this is a windstorm, and nobody's going to pay anything. And so we're going to be left with like a bunch of blue tarps sitting on our roofs. And so my personal belief, my reaction is we shouldn't have to pay as much for insurance anymore. They have made the argument that the tort reform bill is going to result in us not having to pay as high of a premium. They are blaming high premiums, which if you live in the state of Florida, premiums, my personal homeowner's insurance premium has gone up 100% over the course of the last 4 years. It has more than doubled in the cost. So if the argument is that this is suddenly going to relieve the insurance industry of all these burdens, well, my expectation is that my premium should come down dramatically.
That's logical, isn't it?
And if they don't, I think that every Florida homeowner should make a demand to either immediately have their premiums lowered, or they should tell their banks that have their mortgages that they refuse to pay for the insurance that's required under those mortgages because their rights have been diminished and the insurance industry has lied to them about what the result of these tort reform bills are going to be. Now, of course, we all know that the premiums are going to continue to rise. They're not going to go down.
Most likely.
Right, and the insurance companies are going to continue to make lots of money on all these premiums, and us as the consumer are going to be the ones that are going to continue to suffer because we're not going to get a break on premiums. And now when we have a problem, we will have no recourse. That's the result.
Likely.
So I guess that's all we're going to talk about here on Trials and Tribulations today with respect to tort reform. But it is a hot topic, and I think that there's going to be more developments. And since Larry and I are both trial lawyers and also working outside in our own business to help trial lawyers either get financing or a special kind of insurance for their case costs, it's going to be a topic that I think we'll continue to cover and discuss. So if you have any comments or anything that you'd like to add, throw it in the comments section of the YouTube channel or on the podcast. We will respond to them, and subscribe and like our channel so we can keep delivering you more content.
We appreciate it. We'll see you next time. Thank you for joining us. This episode was sponsored by LevelEsq.